This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. The Servile State by Hilaire Belloc. Section 15. Section 9. The Servile State has begun. In this last division of my book I deal with the actual appearance of the Servile State in certain laws and proposals now familiar to the industrial society of modern England. These are the patent objects, laws, and projects of laws which lend stuff to my argument and show that it is based not upon a mere deduction but upon an observation of things. Two forms of this proof are evident. First, the laws and proposals which subject the proletariat to servile conditions. Next, the fact that the capitalist, so far from being expropriated by modern socialist experiments, is being confirmed in his power. I take these in their order, and I begin by asking in what statutes or proposals the Servile State first appeared among us. A false conception of our subject might lead one to find the origins of the Servile State in the restrictions imposed upon certain forms of manufacture and the corresponding duties laid upon the capitalist in the interest of his workmen. The factory laws, as they are in this country, would seem to offer, upon this superficial and erroneous view, a starting point. They do nothing of the kind, and the view is superficial and erroneous because it neglects the fundamentals of the case. What distinguishes the Servile State is not the interference of law with the action of any citizen, even in connection with industrial matters. Such interference may or may not indicate the presence of a servile status. It in no way indicates the presence of that status when it forbids a particular kind of human action to be undertaken by the citizen as a citizen. The legislature says, for instance, you may pluck roses. But as I noticed you sometimes scratch yourself, I will put you in prison unless you cut them with scissors at least 122 millimeters long, and I will appoint 1,000 inspectors to go round the country seeing whether the law is observed. My brother-in-law shall be at the head of the department at 2,000 a year. We are all familiar with that type of legislation. We are all familiar with the arguments for and against it in any particular case. We may regard it as erroneous, futile, or beneficent, or in any other light, according to our various temperaments. But it does not fall within the category of servile legislation because it establishes no distinction between two classes of citizens, marking off one as legally distinct from the other by a criterion of manual labour or of income. This is even true of such regulations as those which compel a cotton mill, for instance, to have no less than such and such an amount of cubic space for each operative, and such protection for dangerous machinery. These laws do not concern themselves with the nature, the amount, or even the existence of a contract for service. The object, for example, of the law which compels one to fence off certain types of machinery is simply to protect human life, regardless of whether the human being so protected is rich or poor, capitalist or proletarian. These laws may in effect work in our society so that the capitalist is made responsible for the proletarian, but he is not responsible qua capitalist, nor is the proletarian protected quid proletarian. In the same way the law may compel me, if I am a riparian owner, to put up a fence of statutory strength wherever the water of my river is of more than a statutory depth. Now it cannot compel me to do this unless I am the owner of the land. In a sense, therefore, this might be called the recognition of my status, because by the nature of the case only landowners can be affected by the law, and landowners would be compelled by it to safeguard the lives of all, whether they were or were not owners of land. But the category so established would be purely accidental. The object and method of the law do not concern themselves with a distinction between citizens. A close observer might indeed discover certain points in the factory laws, details and phrases which did distinctly connotate the existence of a capitalist and of a proletarian class. But we must take the statutes as a whole, and the order in which they were produced, above all, the general motive and expression governing each main statute, in order to judge whether such examples of interference give us an origin or not. The verdict will be that they do not. Such legislation may be oppressive in any degree or necessary in any degree, but it does not establish status in the place of contract, and it is not therefore servile. Neither are those laws servile which in practice attach to the poor and not to the rich. Compulsory education is, in legal theory, required of every citizen for his children. The state of mind which goes with plutocracy exempts, of course, all above a certain standard of wealth from this law, but the law does apply to the universality of the commonwealth, and all families resident in Great Britain, not in Ireland, are subject to its provisions. These are not origins. A true origin to the legislation I approach comes later. The first example of servile legislation to be discovered upon the statute book is that which establishes the present form of employers' liability. I am far from saying that that law was passed, as modern laws are beginning to be passed, with the direct object of establishing a new status, though it was passed with some consciousness on the part of the legislator that such a new status was in existence as a social fact. Its motive was merely humane, and the relief which it afforded seemed merely necessary at the time. But it is an instructive example of the way in which a small neglect of strict doctrine and a slight toleration of anomaly admit great changes into the state. There had existed from all time in every community, and there was founded upon common sense, the legal doctrine that if one citizen was so placed with regard to another by contract, that he must in the fulfilment of that contract perform certain services, and if those services accidentally involved damages to a third party, not the actual perpetrator of the damage, but he who designed the particular operation leading to it, was responsible. The point is subtle, but, as I say, fundamental. It involves no distinction of status between employer and employed. Citizen A offered Citizen B a sack of wheat down if Citizen B would plough for him a piece of land which might or might not produce more than a sack of wheat. Of course Citizen A expected it would produce more, and was awaiting a surplus value, or he would not have made the contract with Citizen B. But at any rate Citizen B put his name to the agreement, and as a free man capable of contracting was correspondingly bound to fulfil it. In fulfilling this contract, the ploughshare B is driving destroys a pipe conveying water by agreement through A's land to C. C suffers damage, and to recover the equivalent of that damage, his action in justice and common sense can only be against A, for B was carrying out a plan and instruction of which A was the author. C is a third party who had nothing to do with such a contract, and could not possibly have justice save by his chances of getting it from A, who was the true author of the unintentional loss inflicted, since he designed the course of the work. But when the damage is not done to C at all, but to B, who is concerned with the work, the risks of which are known and willingly undertaken, it is quite another matter. Citizen A contracts with Citizen B that Citizen B, in consideration of a sack of wheat, shall plough a bit of land. Certain known risks must attach to that operation. Citizen B, if he is a free man, undertakes those risks with his eyes open. For instance, he may sprain his wrist in turning the plough, or one of the horses may kick him while he is having his bread and cheese. If upon such an accident A is compelled to pay damages to B, a difference of status is at once recognized. B undertook to do work which, by all theory of free contract, was, with its risks and expense of energy, the equivalent in B's own eyes of a sack of wheat. Yet a law is passed to say that B can have more than that sack of wheat if he is hurt. There is no converse right of A against B. If the employer suffers by such an accident to the employee, he is not allowed to dock that sack of wheat, though it was regarded in the contract as the equivalent to a certain amount of labour to be performed, which, as a fact, has not been performed. A has no action unless B has been culpably negligent or remiss. In other words, the mere fact that one man is working and another not is the fundamental consideration on which the law is built, and the law says you are not a free man making a free contract with all its consequences. You are a worker, and therefore an inferior. You are an employee, and that status gives you a special position which would not be recognised in the other party to the contract. The principle is pushed still further when an employer is made liable for an accident happening to one of his employees at the hands of another employee. A gives a sack of wheat to B and D each, if they will dig a well for him. All three parties are cognizant of the risks and accept them in the contract. B, holding the rope on which D is lowered, lets it slip. If they were all three men of exactly equal status, obviously D's action would be against B. But they are not of equal status in England today. B and D are employees, and are therefore in a special and inferior position before the law compared with their employer, A. D's action is, by this novel principle, no longer against B, who accidentally injured him by a personal act, however involuntary, for which a free man would be responsible, but against A, who was innocent of the whole business. Now, in all this it is quite clear that A has peculiar duties, not because he is a citizen, but because he is something more, an employer. And B and D have special claims on A, not because they are citizens, but because they are something less, viz., employees. They can claim protection from A as inferiors of a superior in a state admitting such distinctions and patronage. It will occur at once to the reader that in our existing social state the employee will be very grateful for such legislation. One workman cannot recover from another simply because the other will have no goods out of which to pay damages. Let the burden, therefore, fall upon the rich man. Excellent. But that is not the point. To argue thus is to say that servile legislation is necessary if we are to solve the problems raised by capitalism. It remains servile legislation none the less. It is legislation that would not exist in a society where property was well divided, and where a citizen could normally pay damages for the harm he had himself caused. This first trickle of the stream, however, though it is of considerable historical interest as a point of departure, is not a very definite moment to our subject compared with the great bulk of later proposals, some of which are already law, others upon the point of becoming law, and which definitely recognise the Servile State, the re-establishment of status in the place of contract, and the universal division of citizens into two categories of employers and employed. These last merit a very different consideration, for they will represent to history the conscious and designed entry of servile institutions into the old Christian state. They are not origins, small indications of coming change which the historian will painfully discover as a curiosity. They are the admitted foundations of a new order, deliberately planned by a few, confusedly accepted by the many, as the basis upon which a novel and stable society shall arise to replace the unstable and passing phase of capitalism. The end of section 15.